Okay, let's dive right in. In the entire world of tax controversy, there is one single document that stands above all the rest. It's the key that can either unlock the courthouse doors or slam them shut forever. Today, we're putting that document, the 90-day letter, under a microscope for a full forensic analysis.
First things first, what exactly is this thing? Let's be clear, this is not just another bill from the IRS. The Statutory Notice of Deficiency, what we all call the 90-day letter, is a very specific legal instrument. It's the IRS's official, final say on a tax deficiency. And more importantly, it is the one and only ticket you get to go to the U.S. tax court before you have to pay a single penny of the amount they claim you owe.
So here's our game plan. We're going to follow the life of this letter, right from the moment it gives a court power over a case to the ticking clock it sets off. We'll dig into the hidden exceptions to its rules, we'll learn how to take apart the penalties it carries, and we'll even see what happens when it gets tangled up in the super complex world of bankruptcy law.
All right, to really get a handle on this letter's power, you have to start with its most basic function, and it all boils down to one critical legal concept: jurisdiction.
You know, you don't even have to take my word for it. The IRS spells it out right in their own playbook, the Internal Revenue Manual. The letter's main job is to kick off your client's right to a prepayment judicial review. Simple as that. Without this letter, the tax court has zero power to hear the case. It is literally the only key that fits the lock on the courthouse door.
So what makes a notice legally valid? I mean, not every letter you get from the IRS is created equal, right? A true forensic analysis has to start at its very foundation in the tax code.
The source of all this power comes directly from Internal Revenue Code Section 6212A. This is the part of the law that gives the IRS the green light to determine a deficiency for income, estate, gift, and a few other taxes, and this is crucial, to notify the taxpayer using a very specific method: certified or registered mail.
Now this brings us to what is probably the single most fought-over issue in these cases: the last known address. You see, Section 6112B1 gives the IRS what's called a safe harbor. If they mail that notice to the last address they have for you in their system, it's legally valid, even if you never ever receive it. This is so important. The clock starts ticking the second that letter is mailed, which makes keeping your client's address up to date with the IRS absolutely critical.
And once that letter is properly mailed, a clock starts ticking, a very unforgiving jurisdictional clock. And this deadline, well, it's the fulcrum that the entire prepayment litigation system balances on.
So Internal Revenue Code Section 6213A lays out two very distinct and very strictly enforced timeframes. If you're a taxpayer in the U.S., you get 90 days. If that notice is addressed to someone outside the United States, the window gets a little bigger. It expands to 150 days.
But here's the thing. In our digital world, a new trap has popped up. Just look at the case of Mutt v. Commissioner. A taxpayer in Alabama filed their e-petition at 11:05 p.m. Central Time, right on the last day. The problem, the tax court servers are in Washington, D.C., and there it was already 12:05 a.m., one day late. The court had no choice but to dismiss the case. It was a harsh lesson for sure. The deadline is absolute and it runs on Eastern Time.
For decades, the answer to that question was a simple, resounding yes. But a recent split among the federal circuit courts has thrown a wrench in the works, creating some real uncertainty for practitioners. Now the answer is more like, well, it depends.
And this table really shows you just how fractured the legal landscape is now. The tax court, in its Hallmark decision, sticks to the old rule. The deadline is jurisdictional, it cannot be extended, period. But the Third Circuit in Culp v. Commissioner completely disagreed. They ruled the deadline is not jurisdictional and can be paused for what's called equitable tolling. Basically, a court can hit pause on a deadline in really extraordinary situations. So what's the takeaway? The chance of saving a late petition now totally depends on which federal circuit your case can be appealed to.
That 90-day letter gives you this powerful shield, a stay-on assessment and collection. But that shield isn't invincible. There are specific carve-outs that every single tax pro needs to know about.
So first, let's just appreciate how powerful this shield is. IRS Section 6213A is crystal clear. Once that notice is in the mail, the IRS is legally blocked from assessing the tax or starting collection for that whole 90 or 150-day period. And if you file a petition, that protection extends until the tax court's decision is totally final. But as I said, the shield isn't absolute. Section 6213B has some very specific exceptions. The IRS can actually go around the 90-day letter process and assess tax right away for things like simple math errors,
or when a taxpayer voluntarily signs a waiver, like a Form 870, agreeing to the assessment.
And this creates a completely different procedural path. You see, with a math error notice, you don't file a tax court petition. Instead, you file a request for abatement, and you only have 60 days to do it. If you make that request, the IRS has to reverse the assessment. Now, if they still think you owe the tax, they have to go back to square one and issue a formal 90-day letter, which finally gets you those tax court rights back.
All right, shifting gears here. Let's dig into a major area of defense in modern deficiency cases, attacking the validity of the penalties themselves, not on the merits, but on pure procedure. So under Internal Revenue Code Section 6751B, Congress put in a really strict procedural hurdle. They wanted to stop the automatic rubber stamping of penalties. So the law now requires that the very first formal proposal of a penalty has to be personally approved, in writing, by the immediate supervisor of the IRS employee who's making that call.
And thanks to cases like Chai v. Commissioner, our defense strategy becomes this really clear forensic checklist. First, you get the penalty approval form. Then, you meticulously compare the supervisor's signature date to the date on the very first letter that proposed the penalty. If that approval is late by even 1 day, the entire penalty can be thrown out. It's an incredibly powerful procedural weapon.
Okay, for our last section, let's look at the legal collision that happens when a notice of deficiency lands right in the middle of a bankruptcy filing. It gets complicated fast.
The second a taxpayer files for bankruptcy, something called an automatic stay slams down. It's a federal law, Section 362 of the Bankruptcy Code, and it basically freezes almost all legal actions against the person who filed, and that explicitly includes starting or continuing a case in the U.S. tax court. Everything just stops.
So how does the tax code handle this? Well, Internal Revenue Code Section 60-2013F resolves the conflict. It pauses that 90-day petition clock for the entire time the bankruptcy stay is active. But here's the really important part. Once the stay is lifted, the clock doesn't just pick up where it left off. The code actually tacks on an extra 60-day grace period before the leftover time starts to run again.
And trust me, failing to account for this 60-day tacking period is such a common and costly mistake. The new deadline isn't just the time that was left on the clock. It's the time left on the clock plus a fresh 60 days. This little provision can be a critical lifeline, giving taxpayers a brand new, bigger window to get to tax court after they emerge from bankruptcy.
So we're left with the big question. You've dissected the letter, you've calculated all the deadlines and their exceptions, and you've hunted for procedural flaws. What's the best strategy now? Well, a deep, forensic understanding of this one document doesn't just protect a client's rights. It uncovers leverage, it reveals defenses, and ultimately it builds the entire foundation for the controversy that follows.